Welcome to Lawline with your host, Alan Schnorman. Mr. Schnorman is a distinguished trial attorney, author, and lecturer. Each week, Lawline will bring you the most knowledgeable experts in the field of law today. And now we introduce our guest and our host, Alan Schnorman.
Welcome to Lawline. The highly publicized trial of Dr. Veronica Prego, the AIDS-infected doctor, captured the nation's attention. It brought into focus the concerns of the healthcare workers from doctors on down in contracting AIDS on the job. Today we'll discuss the Prego case and the unusual step taken by the trial judge to seal the court records. Our guests are the Honorable Aaron Bernstein, Supreme Court Justice, Kings County, the presiding judge of the Prego trial, and Diane Wilner, Dr. Prego's attorney. Hello, Judge Bernstein. Hello, Diane. Diane, how is Dr. Prego doing today?
Well, as with everyone with the disease, you know, it is a day-to-day struggle, and she has her good days and her bad days. Since the trial's ended, she's had some real struggles. As I understand it, she's had to change some medications, and she's having a difficult time, I think.
Okay. Judge Bernstein, I know the case has been settled, and I think it was settled for approximately, what was the number, Diane?
It was $1,350,000.
Okay. Now, I know you had sealed the records towards the end of the case. Tell us why you did that.
Well, Dr. Prego had indicated that she might be embarrassed by virtue of a release by the Department of Health and Hospitals Corporation, which indicated that she settled her case for a small sum in comparison to the $175 million that she had sued for. So when we reached the number of $1,350,000, she didn't want that sum to be compared to the $175 million that she had sued for. So as part of her request during the settlement negotiations, everyone agreed that we would keep that information from the public as long as we possibly could. We knew that at the very least, the Freedom of Information law would,
for the press,
for anybody, would be entitled to get that information eventually.
Although I must say, Judge, though, I have a slightly different recollection of the events. I mean, I recall that when we reached the settlement in the evening hours of the day before it was announced, thanks to your good offices, it was agreed by both parties. The Council for Health and Hospitals, Council for the City was there, and a representative from the Controller's Office, and of course we were there. And it was agreed by all of us that it would be kept confidential. And I think it was based on that agreement that the next day, when we were putting it all on the record, that you ordered it because there was some question.
There's no question that everybody agreed on, and I didn't say to the contrary. What I was trying to say was that the reason that I agreed to keep it secret was because Dr. Prego indicated that it looked as if she was selling the case out if she took a minor sum in comparison to the amount that was demanded.
Let's address that issue. I remember seeing the jury. Actually, they were interviewed after the trial. In fact, I think he said they went out to lunch together and they basically decided the case.
That's right, as I understand it.
And the one juror that I saw interviewed said something that, well, I would have given, or we would have given, $25 million.
25, 30, something in that range, that's right. The interesting thing is, you know, throughout the trial there were numbers bandied about as to what the action was suing for.
Were you negotiating throughout the trial?
Well, no, because there was never any money put up on the other side until very later on in the trial. Judge, you can correct me if I'm wrong, but I think it wasn't until the final week or two that there was real discussion.
Well,
it was well into the trial.
Real discussion. There had been a sum of money, I think $750,000 was the first sum put up by the city, and that was probably 3 weeks or so before the final settlement.
Right, but that was 3 weeks into a, what, 12-week...
It was
12
I mean, we were 12 weeks on trial, so that would have meant it was 9 weeks into trial. And I must say that we had tried from the very beginning to settle this matter. In fact, I had personally contacted the city prior to ever having a complaint filed in hopes of resolving the matter without ever going to court, because I felt that the ramifications of a case of this magnitude with the first doctor going to trial on an AIDS issue would be tremendous in terms of recruitment of healthcare workers in this city, nurses, physicians, lab technicians, etc.
Diane, how did you know that the $1,300,000 was the right number, and the right number wasn't $1,500,000?
Well, we didn't know what the right number was in that respect, but we had no choice. I mean, there is no doubt in my mind that they would have appealed the verdict. And there was no doubt in my mind that even with an expedited appeal, it would take some extended period of time to go through the entire appellate process. There were issues for appeal.
Well,
Clearly.
what was your position? Did you feel very confident regarding the appeal?
Absolutely. I always felt we would succeed on the case. That was never an issue in my mind, but the pressures of representing a client who has a terminal illness, you have to keep in mind what is the client's need. And the client's needs always were to make sure she had enough to take care of herself throughout the course of the illness. It wasn't to come into some great windfall after she was no longer here.
Yes, but of course I remember that the papers reported that some of the testimony of the economists truly showed her lost wages in the tens of millions of dollars.
Absolutely.
Yeah,
the low
but-
number, I'm sorry, was I think 30 million
something
in lost wages?
But you have to realize that 20 or 30 million dollars that Dr. Berenson was talking about was based upon what would happen after she died, because the prognosis for her life expectancy was a year. And there was a serious question of law as to whether or not Dr. Prego can recover the money the lost earnings that would occur after she died. In most wrongful death actions, that money belongs to the estate.
Right.
And I had, based on another decision by Judge Weinstein, had told the parties that I was going to charge that she could recover it. But there is a very serious question. And if it was wrong that she would be allowed only 1 year, then $1,350,000 would be a substantial sum.
Is that her life expectancy? Would the doctors
Well,
testify 1 year?
her physician did testify at trial that it was anticipated to be 1 year, with the caveat that you never know with AIDS patients.
Judge, it was reported in the press that there was an aborted settlement. Can you tell us about that?
Well, 2 weeks before the settlement was negotiated, the final one, there had been an agreement on just on a sum of money. But there were other factors which we thought we had worked out, but apparently we hadn't. One of the things was the amount of medical care that would be provided for Dr. Prego between the time of the settlement and the end of her life.
Diane, Dr. Prego was supposed to be here today. I know she's not here because of illness. But from your knowing her, what is the stress on potential litigants, especially with AIDS, going through this whole process of a 9, 10, 11-week trial?
It's enormous. I mean, I recall one day we were on the way to the courthouse, and I would pick her up with a car in the morning to go to the courthouse. And as we were approaching the courthouse, she fell ill. And I asked her whether she could go on, and she said she wanted to try because she wanted to get the trial over with. And indeed, that day, you'll recall, she took the stand,
It was a
and
Friday.
she was too sick to continue, and had to leave the stand.
And that was the day after the doctor had announced that he predicted she had somewhere around a year to live.
I think that's correct.
And it was the
That
next morning
right.
that she said that she was too ill to continue on. And
I
she
think-
took the weekend off because the next day was Saturday. It was a Friday that she took the day off.
What problems did you have as the presiding judge of a trial of one, this was one of the first cases in the United States where a healthcare worker was suing for contracting AIDS, and the length of the trial and having a witness who had AIDS on the stand?
Well, of course, you have to be concerned about her welfare and not put too much stress on her. And throughout the entire trial, anytime she requested any kind of a recess, any kind of a break, I gave it to her more than gladly. You also have to be concerned about whether or not she might be concealing it. And I looked at her to see if there were at any time that she was looked ill or looked tired, and if that were, I never saw it, but if there was such a situation, I would have declared a recess or let her go home.
Diane, we're going to take a break now, but right after the break, I'm going to ask you what you thought the jury's perception of Dr. Prego was. You're watching Lawline. Stay with us. This is Alan Schnorman, your host.
There's a reason people whisper when they tell you a rumor. It's because 9 times out of 10, it's not true. Take all the rumors about AIDS. People are saying you can catch AIDS from a mosquito bite or in swimming pools. The fact is there isn't a single case of AIDS on record caused by casual contact. It's up to you. You can believe the rumors or you can get the facts.
Rumors are spreading faster than AIDS. Call your local Red Cross for the facts.
The party's over. All over, one for the road. All over for the 25,000 Americans who die each year as the result of drivers who drink. Drivers who don't realize how little it takes to turn the average social drinker into a tragedy. So please, take this advice from this station and the members of the New York State Bar Association. When in doubt, don't start out.
And now a word from the American Lung Association. Your lungs are an incredible piece of machinery, but your lungs are also incredibly delicate. Diseases of the lung are among the most frequent causes of suffering, disability, and death in the United States. Lung cancer is now the #1 cancer killer in America among both men and women. Chronic bronchitis and emphysema are marked by chronic obstruction to the airflow. Among chronic diseases, asthma is the leading cause of school absenteeism. Yes, TB is still with us. In the past year, over 22,000 Americans have contracted TB. Lung trouble can come from the air you breathe at work, but thanks to the American Lung Association, you can breathe a little easier. They're working to fight all this lung disease. Your lungs are a miracle. Take care of your lungs. They're only human. And if my lungs weren't in great shape, I couldn't have said all this. The American Lung Association. The Christmas seal people.
Hello, I'm Alan Schnorman. You're watching Lawline. Today we're discussing the Prego trial. Our guests are Judge Aaron Bernstein, the judge presiding at the trial, and Dr. Prego's lawyer, Diane Wilner. Diane, before the break, I had asked you what the perception of the jury was to your client.
Well, after the trial ended, we had an opportunity to speak with the jury, and in fact, Dr. Prego went back with us to speak with the jury. And to give you an example, one juror actually embraced her. I think that the jury was overwhelmingly
That's startling.
in her favor. Yes, it was startling. I was very surprised.
He did that in open court. And on the television camera, I think it was juror number 1, the foreman.
Yes, that's correct, Your Honor.
Yeah.
And I think uniformly they all had tremendous respect for her courage and a sense of the great battle that she was going through.
Did you feel it was a sympathetic jury?
I think so.
One of the jurors I heard during the television interview state that they felt that Dr. Fogel, who was really the protagonist, came over as a very cold witness, and for that reason they had sided with Dr. Prego after the trial.
Diane, what were the issues?
You know that we had completed the entire trial, and all the testimony and evidence was in. It was summations and charge.
So all the jury had to hear was the law as it applied to the
Right.
facts, and then they would have rendered a verdict.
That's correct.
And the summations.
And the summations, which basically just summarize what they've already heard.
Well, that's right.
And you know better. That also includes very persuasive argument by counsel.
Well, it's pulling it all together for them, as we like to believe.
Tell us what the issues were.
There were a lot of issues in the Prego
The
case.
thrust
I mean,
of the case.
The case was essentially a negligence case. You know, were the defendants negligent in causing Dr. Prego to get AIDS? In other words,
Well, let's stop for a second.
Yes.
Now, Dr. Prego sued the hospital where she worked.
That's correct.
Normally, a doctor who works for a hospital, if they do contract a disease there, I assume it's workman's compensation.
That's correct. But at the time that Dr. Prego suffered the needle stick injury at question in the trial, she was not a paid employee. She was what was known as an extern. She was a foreign medical school graduate who had come to provide services at Kings County while they sort of looked her over.
So what did you say? What was your position that the hospital did wrong?
We had a number of positions. One, that they did not take adequate precautions to prevent needle stick injuries. We claimed that there should have been needle disposal units at or near the bedside, readily accessible to the people who are drawing blood, so that needles could just be dropped into the units and not had to be carried.
However, there was
Yes,
a
Judge.
substantial evidence that those kind of disposal units were not in rooms back at the time when Dr. Prego's contracted her illness.
That wasn't the standard, though.
From what most doctors...
That was a fact question,
But I
for
think
the
most
jury.
doctors, including your own, agreed that they weren't in the room.
No, I beg to differ. He said at New York Hospital where he was working at the time.
No,
they
but I'm
were.
talking about all your other doctors who weren't at New York Hospital. For example, I forgot his name, but he was the gastroenterologist from Brookdale. He said they didn't have it in the rooms at the time.
Well, doctor, if the hospital, Kings County, if they met the standards of the medical community,
right.
isn't that all they have to do?
Exactly. I'm not so sure. In my own mind, I don't think that was really an act of negligence. I really think the primary issue was, did she get a needle stick in that day in January? Was it 83?
82. 80. I've forgotten the date.
Well, whatever it was, I know it was in January, and by virtue of Dr. Fogel leaving this needle in among other medical debris, and when she went to clean it up, she impaled herself with the needle. Now, in my opinion, I think they did prove that, and I think that would have been the only issue of negligence, because of Dr. Fogel, having been an employee of Health and Hospital Corporation, they would have been responsible for her negligence under respondeat superior.
But Diane, could the jury have believed that she might have gotten it some other way?
I don't think so, because we did exclude any other source of infection in terms of, I mean, when you think of what are sources of infection, sexual contact.
Well, didn't they go into her background?
Absolutely, and we put on in our case that, in our affirmative case, that her two sexual partners were negative, therefore she couldn't have contracted it from them. And of course there were no other sources. I mean, there's no IV drug abuse or anything like that in the case. So the only source could have been a needle stick injury. And in addition, we were fortunate in this case because Dr. Prego was part of the first, or one of the first studies ever done of the prevalence of the virus among healthcare workers. And in that study, it was documented that she had gotten the infection from a needle stick, and this was well before she had AIDS, well before there was any question of the legal and a trial.
Or any motive
to
But of course, that's
lie.
her own testimony. Nobody was present.
No, the hospital records.
Oh, there was?
That she had, she went to the student health service and said, I got a needle stick yesterday from a patient who had AIDS. That was documented.
Judge, what happens today in the medical community? If that very thing happens today, does every medical student, nurse, doctor have a cause of action?
More than likely, they will be an employee, and the workers' compensation law would apply. In this case, because of her unusual status as an extern, I had concluded that the workers' compensation law was not applicable.
Diane, what about a doctor who goes into a hospital because he treats patients there? He has privileges. And due to the negligence of the hospital or another doctor, he sticks himself. Does he have a cause of action?
That's a very good question. I mean, I don't think you have the workers' comp barrier, but there may be other
Assumption of risk.
There may be other legal doctrines to prevent the recovery.
Because AIDS is so prevalent today, the
No,
doctor may be
because
assuming the
doctors
risk?
who know when they go into a hospital, they may subject themselves to illnesses which are are infecting patients in that hospital.
Judge,
I
are you
don't
saying
think-
a doctor practices at his own risk?
I think a doctor practices or may practice knowing that when he goes into a hospital, he may contract an illness.
Diane,
I don't think that he assumes a risk of negligence.
No.
I mean, I think if you can show negligence, again, assuming there's no workers' comp bar, I think there is a cause of action. But one of the nice things that I think has come out of this whole trial is the healthcare community is very mindful, I think, of trying to prevent accidents that could lead to an exposure to AIDS virus.
we have to take a break now, but I want you to think about, can a doctor or a dentist just refuse to treat an AIDS patient? You're watching Lawline. I'm Alan Schnorman, your host. Stay with us.
My father taught me to steal and to pitch. Today I struck out 7 and stole home. I think Dad would have been proud. Coach was. He said he wished Dad had taken as good care of himself as he did of me and Billy. Billy won't talk about it, and Mom can't stop crying. I don't know what it's like to have a heart attack. Except I can see it hurts. It hurts bad.
You can help prevent heart disease. We can tell you how.
My father, Gordon McRae, was one of the biggest stars in musicals. He was also an alcoholic. When I was little, I thought I could stop my dad from drinking. But only the alcoholic can do that. And finally, my father got help and stayed sober the last 7 years of his life. I was so proud of him. Alcoholism is treatable and preventable. Be alert to signs that you might need help, especially if you're the child of an alcoholic. For information, call the National Council on Alcoholism, 1-800-NCA-CALL.
Talking computers, high-speed braille printers, new technology helping blind and visually impaired people participate fully in today's computer age.
And removing the top of page.
For more information about putting high technology to work for blind people, write American Foundation for the Blind, National Technology Center, Box 111, New York, New York, 10011. The American Foundation for the Blind.
Diane, for all the healthcare providers who are out there, can they refuse to treat an AIDS patient?
I think that's an area of the law that's not 100% settled as yet, but there have been cases. In fact, there was one case in New York where a physician or a dentist, I forget which it was, refused to treat somebody who had been a patient and then who acknowledged that he had AIDS. And it had gone through the Human Rights Division and then into the courts, and it was held that he couldn't refuse. And I know, of course, the AMA has taken positions on that as well.
So you're saying the doctor, nurse, or dentist has the choice of either practicing or not, but if you're going to practice, you have to accept AIDS patients.
I think if you look at at what's gone on through the decade of this epidemic, there have been a lot of ethical debates as to whether they can or cannot refuse treatment. The hope is that all AIDS patients will be treated, and they'll be treated in a safe environment.
Now, I know you've, because of your preparation for the trial, are very familiar with AIDS. Is AIDS, at least, is it amongst homosexuals, has it leveled off?
You know, I really am not the one to give epidemiological data, but I think if you read the studies, there had been a leveling off in all likelihood due to the community's practices of safe sex and taking other measures to avoid the spread of the virus.
Are we closer to finding a solution than the beginning?
I hope so.
From your research?
You mean a cure?
A cure.
I mean, I really don't know. You have to speak to NIH about that, I would guess.
Well, I think that there are remarkable improvements over the decade. Remember that if we go back to the early 80s, at the time that Dr. Prego had the needle stick, there was no such thing as AZT. And today, AZT is doing wonderful things for at least giving AIDS patients expanded life and a quality of life.
Judge, if you had a crystal ball, where do you think the court system is going to be vis-a-vis AIDS cases in 5 years?
You mean on AIDS patients who claim they contracted it through the negligence of someone?
That's correct.
I imagine you're going to be just where you are today. Whatever number of cases you have, they'll be brought.
Do you know of any other cases pending?
I don't know, no.
Diane, do you know any other cases pending?
There is a case in New Jersey, I know, pending. I haven't heard of too many. There's one in Florida. I don't think there are any more in New York City, at least at this point. I think there's one upstate. They're difficult cases, you know, because of the pressures in dealing with a terminal patient. And one of the things that I must note is that I think the legal system responded remarkably well to expediting, and much of it is to the credit of Judge Bernstein in handling the case.
Judge, I know in criminal trials with AIDS defendants, there's a whole list of items for the court personnel. Did you have any problems
No.
regarding that? I know they wear gloves in criminal cases, and they stay...
Well, in criminal cases, you know, people are not as controlled as Dr. Prego was. They were concerned about violent outbreaks by AIDS patients where they might try to bite somebody. Here we had no problem. I had 2 court officers consistently during the trial, and they didn't wear gloves. They didn't object in any way. In fact, I think they were very solicitous of Dr. Prego. They escorted her wherever she wanted to go.
They were wonderful, in fact. In that
Now, I know you had the long trial, and then it was on television. How did you feel about the cameras in the courtroom?
The first maybe hour or 2, you felt a little self-conscious. But just like here, you know, I don't even realize the cameras are going.
Because I'm here.
That's true. You are a very attractive speaker.
Flattery will get you everywhere. If you had to retry the case today, would you have done it any differently?
Well, I don't think so. I maybe one or two rulings I would have changed.
What?
I think the one ruling I felt that I really made an error in was in allowing the City Health and Hospital Corporation to introduce a second expert. I think that was an error. And I also, during the aborted settlement discussions that we were talking about earlier, I urged Dr. Prego to do something which I really now feel was wrong. And I did that. You know, my motives were good because I felt that we would be getting her a settlement that would end her problem in the courthouse and let her just concentrate on enjoying the remaining days or years that she may have.
If you had to retry the case, would you do it any differently?
Probably not. I think I tried essentially the way we did. We planned our witnesses carefully, and
Are there any surprises from you from the defense?
No, there weren't, which is always
Surprise
nice.
witnesses or...
No, on one or two occasions we thought there might be. We were not really surprised at all in any of the substantive areas, and were prepared for them.
The biggest surprise, I think, was their witness on rebuttal, the doctor who testified that Dr. Fogel had, on previous occasions, left debris, needles embedded in debris, in medical debris, and she said that her practice was that she never did, and they brought in a doctor who worked under Dr. Fogel, who said that she customarily did that.
Now, Diane, this was a doctor you had in your hip pocket,
This
that
was,
expression?
actually, this is one of those stories where right before the trial was to begin, within a week prior to trial, we ran out on a Friday night, in a snowy night, out to this fellow's home in Long Island. He had been a medical student working under Dr. Fogel, and we interviewed him, and he told us this information. And then we had to make a decision as to when to use him, but he was, at that point, we knew we had a powerful piece of evidence to put on in the trial.
I think they had to use him in rebuttal because
Yes.
I don't know that they could have gotten that in without the prior testimony that her habit was, her custom was not to leave it, and therefore she could conclude that she didn't do it on the day in question. So that when you...
Certainly,
when
and, and then the case was settled.
Right. And
Judge
we, in fact, had made that decision. We couldn't have gotten it on the record.
Judge Aaron Bernstein, Diane Wilner, thank you both for appearing on Lawline. And as always, this is Alan Schnorman, and thank you for watching Lawline.
You have been watching Lawline with your host, New York trial attorney, author and lecturer, Alan Schnorman. Mr. Schnorman will be back with you next week at the same time. If you have any questions or comments about this week's program, please write to Lawline, 27th floor, 63 Wall Street, New York, New York, 10005.